This is a lecture on conditions. First of all, it's important to know about conditions because substantial performance is a branch of conditions. And substantial performance is tested very frequently on the state bar exam. So you really got to know about substantial performance. And it's a subset of conditions, and so you've got to know about conditions. To understand conditions, let's begin with where we are in the total scheme of the law of contracts. Where does conditions fit into the scheme? And the pattern is something like this. When we form the first step in the law of contracts, of course, is forming the contract. Formation of the contract. And this is where we have all that material about offer and acceptance and consideration and all that stuff that you know about. After the contract has been formed, the next problem is to interpret the terms of the contract. And in this area, we have problems such as the problem of mistake, ambiguity, parole evidence rule. And these are all problems where you have a contract, but you're not quite sure what the terms are because, for example, there's a word in the contract that has more than one meaning, or there's a word in the contract that's a term of art in the world of plumbing, and you got to figure out what that means, and so forth. So ambiguity, to learn what the terms are. Secondly, the parole evidence rule. The parole evidence rule is also about determining the terms of the contract because that brings up the problem where we have a written contract, but before we had the written contract, or at the time of signing the written contract, there were some additional expressions, either oral expressions or written on some other documents. And the question becomes, do these other expressions, these parole expressions, become a part of the contract or not? And the parole evidence rule says basically you cannot use that material to add to, vary, or contradict the terms. And the third issue here is mistake. And this, of course, is self-explanatory, where you meant one thing but you wrote something else down, and how are you going to deal with that? After we have formed the contract, clarified the terms, the next important thing that happens is that people may want to change the contracts. Now you need, some rules about how can you change your contract, because every other kind of legal arrangement that you can make, there's always a way to change it. You write a will, you can change the will. You write a trust, you can change the trust. You create a corporation, you can amend the articles, and so forth. So we need a way to change the terms of the contract, and these changes in the contract there are two types of changes, and those are you change the terms of the contract, or you can change the people in the contract. The way you change the terms of the contract, of course, is to modify the contract. And there are some terms, some rules about what it takes to modify a contract. The way you change the people in a contract is, imagine that you and I have a contract, and I have rights and you have rights, and I have duties and you have duties. Let's suppose that I assign my rights to some third party. Well, we've now got another person in the contract who wasn't there before. I may or may not still be in the contract, but the point is that we've changed the people. We now got this other person. Likewise, if I have some duties under the contract and I delegate these duties to somebody else, we now have changed the people in the contract. And then finally, the novation, if you and I have a contract and we agree, you and I and some third party, all three of us agree, that the third party is going to replace me entirely in the contract in every way, that's called a novation. So that's another way to change the people in the contract. Please notice that the novation is a little different than, say, the delegation, because if I delegate my duty to you and you are obligated to perform, I'm not free. If you don't perform, I'll have to. So I'm still in the contract in that case. But the novation completely takes me out and puts the other person in my place. So that's three ways to change the people: assignments of rights, delegation of duties, novation. And another way to change the people is if we form a contract that's a third-party beneficiary contract. That is, you and I form a contract for the benefit of this third party. I'm going to buy a car from you and I want you to deliver the car to this third party. So we form a contract for the benefit of the third party, and now the question becomes, suppose I want to take this third party out of the contract. Okay, I form the contract, I'll buy a car from you, you want to deliver it to Mary, and I say, no, I don't want to deliver the car to Mary anymore, I want to change the contract. So I'm taking this person out of the contract who used to be there. And can I do that? And for how long can I do it? The answer, of course, is I can do it as long as this third party's rights have not vested yet. But if they've been vested, then I can't do it. And so the point here, though, is that we started out with three people in the contract. We started out forming a third-party beneficiary contract, and now I want to remove the person. That changes the people. It reduces it from 3 to 2. So the ways that you can change the people in the contract are you can assign rights, delegate duties, innovation, and finally, if we have a third party, we start with a third party beneficiary contract and we remove somebody before their rights vest, that changes the people. And there are rules of law, of course, about each of these things. So far we have formed the contract, we've interpreted the terms, we've made changes, if any, and from there we come to the next step, which is a possible breach of contract. I'm going to erase this just to make room on the board here because we don't need it right now. So the breach. How do you decide if a contract is breached? We'll talk about that in just a second. After the breach of contract comes remedies, where the non-breaching party wants remedies for the breach. And these remedies, as you know, can be legal or equitable. The legal remedy is money damages, always, with two exceptions. Ejectment and replevin are the only exceptions. Otherwise, the legal remedy is always money. And the equitable remedy, of course, can be rescission or specific performance or other things that equity does. And finally, the last area here is quasi-contract. The quasi-contract issues come up when we have, we either never had a contract and I did some work for you and I want quantum merit to get paid for what I did because I thought we had a contract and we didn't. So we either never had a contract, in which case you use quasi-contract, or we had a contract, but partway through the contract something happened and the contract got terminated. For example, a contract may be terminated by destruction of the subject matter. I'm supposed to paint your house, and halfway through the paint job your house burns down. Well, I can't finish the paint job, but I get paid quantum merit for the work that I did, quasi-contract. So the quasi-contract issues come up when the contract got terminated or never existed for some reason, and you got to do what's fair to people. So these are the big areas of the law of contracts, and here is the area where we're going to be working right here, breach of contract. So the question now becomes, how do you decide whether or not there was a breach of contract? And the answer is that there are three requirements for a breach of contract. Those three requirements are, number one, that if there were any conditions precedent to my duty to perform, they have occurred. For example, suppose I'm supposed to paint your house following the first 3 dry days in September, and there haven't been 3 dry days, consecutive dry days in September, then the duty to paint your house simply isn't absolute yet. So if you sue me before that happens, I don't have a duty to paint yet. So you'd lose. So if there are conditions precedent to my duty to perform, if you're going to claim I breached, the first step is have all those conditions occurred. So those conditions precedent must have either occurred or been excused. And here is where we're going to be working today. Secondly, for a breach, time for performance must have arrived. That is to say, if I'm supposed to finish your paint job by September the 15th, and it's now September the 1st and I haven't finished yet, well, you can't sue yet unless there's prospective inability to perform. On September the 14th, when I haven't even started your paint job and it's a 6-story apartment building and I can't finish it in one day, now you have prospective inability to perform. You can sue early in those cases. Or anticipatory repudiation, where I tell you before anybody has done anything, I tell you I am not going to perform when my time comes. Well, you don't have to go ahead and perform anyway and wait and see if I believe it, if you believe it, pardon me, if you should believe it. If I tell you I'm not going to perform, then that's anticipatory repudiation. You don't have to wait. You can sue early. So we have these cases here, prospective inability to perform, anticipatory repudiation. But except for those exceptional cases, you have to wait until it's time for me to perform to see whether or not I'm going to perform or I'm going to breach. So a breach of contract requires all conditions preceding to my duty to perform have occurred or been excused, time for performance has arrived, and the final requirement is that the duty is not discharged. And my duty to perform the contract can be discharged in a lot of ways. For example, I can discharge my duty by performance. If I've done it once, I don't have to keep doing it. I can discharge my duty by my duty can be discharged by illegality. So that, for example, I was going to build your house at this location, but before I started building, the zoning changed, and it's now illegal to build a house there. So my duty is discharged by illegality. My duty can be discharged by impossibility. I'm supposed to paint your house, but it burned down. My duty can be discharged by a number of other ways, accord and satisfaction, and so forth. So the breach of contract then requires that, and if you're going to say that I breached, all conditions preceding to my duty to perform must have occurred or been excused, the time for my performance must have arrived, and my duty to perform has not been discharged by any of this list of stuff, and you have the complete list elsewhere. So we are brought to the point here of conditions, and this is what we're talking about, conditions right here. And if a condition has occurred, we don't really have a problem. Okay? If I'm supposed to paint your house following the first 3 dry days in September, and it's been 3 dry days, well, the condition has occurred, and that takes care of that. But what about those cases where the condition has not occurred, and there are a whole series of situations where the legal system itself will excuse those conditions, so you don't have to have that condition anymore. Suppose the condition becomes impossible to occur, for example. Then you may be excused. So what we're going to talk about today are the ways in which a condition can be excused. This is the heart of our discussion. Now, in order to proceed with this, let's begin with a better understanding of what we mean by conditions. When you really say that a condition precedent to my duty to paint is that there are 3 dry days in September, or the condition precedent to your duty to pay me for the paint job is that the paint job is completed, or that a condition precedent to your duty to pay me for the widgets is that I have delivered them to you. And so these conditions precedent occur all the time, and we need a better understanding of them so we can see how to deal with the problems. Step 1 in understanding these conditions better is to first of all understand that the conditions are really an event which must occur before my duty to perform to you becomes absolute. If I am building an apartment building for you, and the deal is you're going to pay me when it's finished, well, then when I present you with the finished building, that's the event that makes your duty to pay me absolute. So the occurrence of an event makes your duty to perform absolute. Lots of situations like that. I build a house for you, and the deal is that you are going to pay me when you get the architect's certificate of completion. Well, getting the architect's certificate of completion is the condition precedent to your duty to pay. It is the event which must occur. And I want to think about it and talk about it in terms of events which must occur rather than in terms of conditions. When you speak about things in terms of conditions, that's in terms of logic, kind of. You speak of them in terms of event, and it's much clearer what's going on. You can imagine events. It's hard to imagine conditions. So when you say that in my house building case, the event which must occur before you have a duty to pay me is that you receive the architect's certificate of completion. And it's these events that this lecture is about, and we need to talk about them somewhat in depth. Now, the first thing to talk about regarding these events is whether or not the public is willing to enforce that kind of an agreement. If you and I form an agreement where it's a contract, where I'm going to do something for you and you're going to do something for me, and we understand that if I don't perform, the public is going to come in and make me perform. If you don't perform, they're going to come in and make you perform or give me damages in place of it. And when we form a contract, what we mean by that is that we have this set of promises and that we intend for the public to come in and enforce the promises if we don't do it. Okay. Now we got a contract. Now, the public may or may not be willing to enforce these contracts, for example, or these agreements. You and I have an agreement where we're going to the movie together tomorrow. And we've got an agreement. The public isn't going to come in and enforce that agreement. We have an agreement and I committed fraud. I got you to agree to do something for me by fraud. The public isn't going to enforce that. You are a 3-year-old baby and I got an agreement with you to do something. The public isn't going to enforce that. So there are lots of agreements that I can make with people that the public simply is not going to enforce. And these events that we're talking about that make my duty to perform absolute, those events present a similar kind of problem. For example, if the event is that I will pay you, we have an agreement, and I will buy your house for $100,000 if George commits suicide. You know, the courts are going to have anything to do with that. I defraud you into getting this agreement. I'm not going to enforce that. So what I'm getting at is that the event which needs to occur in order to make my duty to pay, to perform absolute, that's what we're focusing on, that event. There are funny things that can happen to that event, and that's what this lecture is all about. Let me give you some examples of these events to distinguish them from promises, because that's one of the fundamental things we have to do is to distinguish the conditions from the promises, and the consequence of breach of promise is different from the consequence of the non-occurrence of a condition. So let's talk about that, and then let's talk about the things that can happen to the event. The events can occur, they can fail to occur, the event may become impossible to occur, we may agree that we don't want the event anymore. It's all about that event, and that's what we're going to talk about. But first, let's understand how we distinguish between conditions and promises. To do this, let's imagine that I'm going to build an apartment building for you, or just a house. I'm going to build a house for you. And the deal is as follows. You're going to pay me $10,000, and when I receive the $10,000, I am going to build a foundation. I promise to build a foundation when I get the $10,000. You give me the $10,000, I build a foundation. Now, when I have finished with the foundation, the deal is you're going to pay me $20,000. And so a condition precedent to your duty to pay me $20,000 is that I have completed the foundation. Now, I promise to complete the foundation, but it's the completion of the foundation that is the event which must occur to make your duty to pay me $20,000 absolute. When I have completed the foundation, presented you with a completed foundation, now you have promised to pay me $20,000. That's a promise, not a condition. You promise to pay me $20,000. If you don't pay me the $20,000, I can sue for breach of the promise. If you pay me the $20,000, now the event has occurred that makes my duty to build the exterior of the wall of the house absolute. And so now that the condition the event has occurred. I've received the $20,000. I have promised to build the exterior. If I don't build the exterior, you can sue me for breach of that promise. But if I build the exterior, and the exterior is finished when I present you with the finished exterior, well, that is the event which makes your duty to pay me $40,000 absolute. So you pay me $40,000. Now, if you don't pay me the $40,000, I can sue you for the $40,000. But if you do pay me the $40,000, then the event which makes my duty to build the interior absolute has occurred. The event has occurred. Now, we say that in conditional language. We say, the condition preceding to my duty to build the interior was that you pay me $40,000, and the event has occurred, and therefore my duty to build the interior is absolute. So you can say that in fancy legal language, and that's good, but it doesn't draw the picture as well as if you think of it in terms of events, that the event which makes my duty to build the interior absolute is the completed exterior. Now, I build the interior, you pay me the $30,000. Now I promise to build the interior. If I don't build the interior, you sue me for breach of promise. Please notice that when you sue me, you don't sue me for the non-occurrence of a condition. That's very important. You never sue for the non-occurrence of a condition. You sue for the non-performance of a duty. And if my duty was absolute, I promised to build the interior when I got the $30,000, and I didn't build it, you can sue for a breach of that duty. But when I build the interior, now the deal is that when I present you with the finished house, you're going to pay me $40,000. And if you don't pay me the $40,000, I can sue for the breach of that duty. So you see how these conditions and promises can go along, where this is a situation where the events which make your duty to pay me absolute, those events, I promise to make those events happen. And that's very different when the event is just some independent event that may or may not happen. I will start painting your boat after the first 3 consecutive non-rainy days. Well, that's an event that may happen or may not happen. But I didn't promise to make it happen. But if the deal is that I am going to paint your boat, and when it's finished, you're going to pay me $50,000 for the paint job, well, I promised to make the event occur. I promised to paint your boat. So we need to distinguish between events which happen on their own and events which I promised to make occur. Because if I promised to make them occur and they didn't occur, breach of that promise is a good lawsuit. But the event itself, you don't sue for the non-occurrence of the event. You sue for the non-performance of the promise. Now this brings us to the events are reasons to excuse the occurrence of these events. That's what this lecture is about. These events which are going to trigger your duty, make your duty to perform absolute. There are a bunch of funny things that can happen to these events, and that's what this lecture is about. Let's list them. The events may be excused by, I'm going to just go to a new board here so we can make some more notes. So the events may be excused by, and here are some things that might excuse the events. Number 1, by waiver. Okay, and we will talk more about that. By prevention. By breach of contract. By the impossibility. By substantial performance. By divisibility. And I think I want to put divisibility last, so I'm going to put here by disproportionate. Disproportionate forfeiture. And by divisibility. let's begin with waiver. Now, let's suppose that we have an agreement where I'm going to build a house for you and you're going to pay me when you get the architect's certificate of completion. Now, you could very well come to look at the house and say, gee, this house looks exactly the way I wanted it to look. I don't need the architect's certificate of completion. I'll pay you anyway. Okay. Well, that's waiving the event. The event was presenting you with the architect's certificate. You're waiving that, saying, I don't need that. I'll pay you anyway. And certainly you can waive a condition like that if you want to. How about this one, though? We don't have the architect in this one. Now I'm building an apartment building for you, and the deal is you're going to pay me $1 million when the construction is complete. So, the event which makes your duty to pay me absolute is the completed apartment building. Now, of course, I promised to build it, but that's beside the point right now. The event is presenting you with a finished building. Now, if you decide to waive that condition, or waive the occurrence of that event, well, if you waive the occurrence of that event, then you owe me the $1 million without the apartment building. And you can see that makes no sense. You've turned what used to be a bargain into a gift, and that's not enforceable. So you can see that for that reason you cannot waive a material provision of the contract. Non-material provisions you can waive. The material provisions you can't, because if you waive them, you will turn what used to be a contract, a bargain, into a gift. So the details here are that you need to distinguish between non-material provisions which you can waive and material provisions which you cannot waive. Prevention. Let's suppose that the deal is that I am to build an apartment house for you, and when the architect presents you with a certificate of completion, you're going to pay me $1 million. Now, what you do then is you go to the architect and you bribe the architect, and you prevent the architect from issuing the certificate of completion. You send them away on vacation for a while. When they get back here, you find ways of preventing the architect from issuing the certificate of completion. You've prevented the event from occurring, the event that is a condition preceding to your duty to pay. Well, you can see that that doesn't produce a fair result. So what's the court going to do? The court's going to say, well, look, if you prevented the event from occurring, we're going to just treat the event like it occurred. So you go ahead and pay. So in the case of this, you may excuse the event by prevention, and then you would have to pay anyway. When you say you excuse the event by prevention, it means that the court would just ignore the requirement for the architect's certificate. Next, breach. Now, let's suppose that, back to this house that I built for you, where you're going to pay me $10,000 and I was going to do the foundation, you pay me $20 and I do the exterior, you pay me $30, I do the interior, and you pay me $40 when it's all over. And so let's suppose you paid me the $10,000 and I won't build a foundation. I just refuse. Either I just refuse to do it, or maybe I even went so far as to tell you I'm not going to do it. And so if I tell you I'm not going to do it, that's anticipatory repudiation. But if I just don't do it, it's still a breach. I just don't do it. And so when you sue me for breach, you say, gee, Emerson, you were supposed to build a house for me for a certain amount of money, and you didn't do it, and I'm suing for breach. And so now I say, well, wait a minute. You paid me the $10,000, and that was a condition precedent, or that was the event that needed to occur in order for my duty to build a foundation to become absolute. Well, that event occurred. You gave me the $10,000, and now I have an obligation to build a foundation. So when you sue me, you should just sue me for not building the foundation, not all this other stuff. Because, for example, a condition precedent to my duty to build the exterior is that you pay me $20,000. You haven't paid me $20,000. And after I finish the exterior, the condition precedent, or the event which has to occur before I'm obligated to build the interiors, you're going to pay me $30,000. You didn't do that. So when you sue, when I didn't build the foundation, I'm going to say, you should just sue me for not building the foundation. And your response to that is that's ridiculous. You wanted a whole house, and you're suing me for not building the house. And the way the legal system accomplishes your right to sue me for not building the whole house, The way you do that is you say, the legal system says, all the conditions precedent to my duty to perform to you, the condition preceding that you pay me $20,000 before I build the exterior, you pay me $30,000 before I do the interior, all those conditions preceding, all those events. The legal system says we excuse all those events. We excuse those conditions precedent. And so if you excuse all the conditions preceding to my duty to perform to you, then I have an absolute duty to build the whole house right now. So now you can sue me for not building the entire house as opposed to just not building the foundation. So the rule with breach is that whoever the breaching party is, that if it's a material breach, not a non-material breach, now we're not talking about that, but if it's a material breach, an anticipatory repudiation is certainly a material breach because you're saying I'm not going to do it at all. Nothing's been done in the case of the anticipatory repudiation. Nobody has done anything, and I'm saying to you I'm not going to do it. Well, that's a total breach. So if the deal is then that the condition precedent to all of my duties regarding the building of the house are all excused. All the events which are supposed to occur before I built the whole house, all those events are excused by law. And now I'm supposed to build the whole house, and so you can sue me for not building the whole house. When you sue me for that, what you will do, of course, is go out and get somebody else to build a house. If they charge you more money, if they build it for less, then you're lucky. If they build it for more, you sue me for the difference. And that's what happens with breach. Next comes impossibility. Now, the condition, the event which is the event which is going to trigger my duty to perform, that event can be anything in the world. In other words, when we make up our contract and there's some event which must occur in order for my duty to perform to become absolute, if that event must occur, I can describe anything at all as the event, doesn't matter. And since I can describe an infinite number of possibilities of what's the event, you can see how you can get into some trouble with that. I mean, for example, the event which I describe might be ambiguous. You're not sure what it is. The event which I describe might be something outrageous, like the example I gave before, I will buy your house for $100,000 if George commits suicide. Well, you know, the court system isn't going to get involved in that. And so the event which I describe, there are a number of problems with that event, and it's entirely possible to describe an event which is impossible. It will never happen. For example, I say I will pay you for the building of my house when my aunt reaches 96 years old. Well, my aunt's dead. Okay, so it's never going to happen. You're going to pay me for the building I built when you get the architect's certificate. The architect died. The event's never going to happen. It's impossible. So what are you going to do in those cases? And you can see that that can produce a very unfair result, what is called a disproportionate forfeiture. You have one person has built a house and the architect died, can't produce the certificate, and therefore you got all this money invested in building the house and the labor and the materials that have been paid for, and now you want to get paid by the owner. And the owner says, well, I'll pay you as soon as the event occurs, but the event's impossible. So that's going to produce a disproportionate forfeiture, an unreasonable, unfair forfeiture. And you can excuse conditions because of the disproportionate forfeiture. So what the court would do in the case of the architect's certificate, they'll say, we're going to decide, we're the court, we're going to say that event is excused. When we say the event is excused, we mean it doesn't have to occur, and you still got to pay for the building. What would happen in reality is the court would say, we're going to treat this like you didn't designate this particular architect, and now you go to general principles, and if I built a building, you're going to get some architect to certify the completion, and they'll do it that way. But the point is that when the condition becomes impossible, that may result in a disproportionate forfeiture, and though the condition may be excused for that reason. On the other hand, consider the situation where the event that triggers your duty to pay me, let's say the event is that I will leave out the architect, and I'm to build an apartment building for you, and this apartment building is on the edge of a mountain, and this mountain has a beautiful view of the valley down below. It's right on the edge, best view in the whole community. And so I'm going to build an apartment building for you there, but before I build the building for you there, the plot of land where the building's supposed to go got washed away by an unprecedented flood. And now it's totally impossible to build on that site anymore. So and you're supposed to pay me when the building is complete. And so it's impossible to complete the building because the site isn't there anymore. So if we excuse the occurrence of the event, we excuse the completed building and say, well, you got to pay anyway. Well, that's ridiculous because you're now paying me for a building you're never going to get. And so you can see that you can't just say every time a condition becomes impossible, we're just going to excuse it. So in those cases where I am the person who promised to make the event occur, and now the event doesn't occur because it's impossible, we'll just discharge the whole contract. If I was supposed to build the apartment building for you to make the event occur so you could pay me, that is never going to happen. The whole contract would simply be discharged. I'm supposed to deliver my car to you and you're supposed to pay me. My car got destroyed. I can't pay you. Contract is terminated by destruction of the subject matter. So when the event becomes impossible because, and I promised to make it happen, and it's impossible for it to happen, we discharge the whole contract. When the event is some insignificant thing like the architect's certificate, then we'll probably just waive the event. Substantial performance. Now, substantial performance is the one that is by far most frequently tested. And there is a separate lecture on substantial performance, but I want you to understand enough of it now to see how it fits into the total scheme. Let us suppose that I'm supposed to build this building for you, this apartment building, and the deal is you're going to pay me when the building is finished. Okay. Now, I build a building, and it's got some specs, and I finish it. There's one door that's not hung yet, and there's also a garage door isn't painted, and there's one window that's not installed yet. And so now I say I'd like to get paid. I come to you and you say, oh, sorry, Emerson, I can't pay you because a condition precedent to your duty to my duty to pay you, if we don't say it in terms of condition, we talk about the event which must occur in order for you to have an absolute duty to pay me is that I present you with a finished apartment building. And you say, this one isn't finished according to specs because these things are wrong with it. And so you don't pay. I say, oh, okay, then I'll put the window in and I'll paint this wall, door. They say, now pay me. And you say, oh, well, I was over at the apartment building last night, you say to me. You say, and there's a molding on the roof that is the wrong kind of molding. It doesn't fit the specs here. So I'm not going to pay till we fix that. And say, oh my goodness, okay. So I go and I change the molding, come back the next day, you say, gee, Emerson, I can't pay you yet because, and on and on and on and on. And you can see that you could probably find something wrong for a very long time, so you end up never paying me. And so we need some way to deal with that in the legal system. And the way we deal with that is we say, look, here's what we're going to do. First of all, it is clear to you, I'm sure, that courts do not renegotiate contracts for people. Okay? Courts are not there for that purpose. They're there to interpret the contract that you made and to enforce the obligations that people have in the contracts. But they don't rewrite the contract. Even if it's a bad contract, they don't rewrite it. But the courts might refuse to enforce certain provisions of the contract. They might refuse to enforce a provision because it was a product of fraud. It was a mistake. There was duress, unconscionability. It was a minor lack of capacity. So any number of reasons that the court might decide we're not going to enforce either the entire contract or some provision of the contract. We're simply not going to enforce it. And so the courts can do that, as you know. Well, if we bargained for this building to be completed exactly according to the specifications, and the reason we need it, it's a real reason we need it exactly according to the specifications, because this is a building that's going to be used in a movie, and we're trying to recreate a certain period of time, and there's certain things have to be exactly right, and you understood that when we negotiated the contract. Well, the courts aren't going to renegotiate that. I have to build according to what was said. If you're going to buy my car for $10,000, the court's not going to say, oh, you can have it for $9,000, because they're not going to renegotiate the contract. They may refuse to enforce the entire contract because of some of those reasons I mentioned, but they're not going to renegotiate it. And so it's all or nothing, so to speak. So likewise, if you and I have negotiated where I'm going to build a building exactly according to these specifications, and I don't do it, I simply don't get paid until I do it. But if these exact specifications are really not that big a deal, you just wanted a decent apartment building, and I built you one, then the courts are going to say, we're not going to make Emerson do all that little stuff there, because that would result in a disproportionate forfeiture. Be forever before I got my money from you. And so the courts will say, no, here's what we're going to do. Rather than have that forfeiture where basically the building has been built but the person is never going to get paid, rather than have that kind of a forfeiture, what we're going to do is we're going to say, no, that if you people were not really negotiating for exactly that high specification exact building, but for a building that's substantially like that, then we're going to say, to prevent this disproportionate forfeiture, we are going to excuse the requirement that I present to you a building which is exactly according to specs. Okay, we're going to simply we're not going to do it. We will not enforce it. They're not changing the terms of the contract. They're saying, we're not going to enforce that provision at all. But we're not going to enforce it if Emerson has substantially performed. If I've come pretty close to doing what you asked me to do, then they're going to say, we're going to wipe out the provision that I have to do exactly what I was supposed to do. We wipe it out on the condition, provided I have substantially performed. Now, exactly what constitutes substantial performance is the subject matter of another lecture. And there are, if you look at restatement, the second restatement, 241, you will see the 5 factors which are used to help decide whether or not someone has substantially performed. And that's on a different lecture. But right now, what I want you to understand is that when the doctrine of substantial performance is used, what the court is saying is that we will not allow the disproportionate forfeiture by enforcing exactly what the contract said when that really wasn't that important to begin with. And instead, we're saying if Emerson has substantially performed, we will wipe out the provision of exact performance. And in that case, you got to pay, if I substantially perform, you got to pay me the contract price, not quantum merit, not quasi contract. You pay me the contract price minus what it takes to fix the minor damage. In other words, if I have only substantially performed, then there is a minor breach. And when you pay me the contract price, you can hold back the damages for that minor breach so you can get your window put in and get your garage door painted and get the other door put back on the apartment building. So that's how the doctrine of substantial performance works. The doctrine of another example of substantial performance that's useful, that gets tested from time to time, is the one where the person says, gee, I want you to build this building for me, and time is of the essence. Okay? And I want it finished on January the 1st, and time is of the essence. So I build the building for you, and what do you know? I finished on January the 3rd. I'm 2 days late, and it didn't really inconvenience you at all. And so on January the 3rd, you say, sorry, Emerson, I'm not going to pay you because you breached the contract. And I say, well, gee, at least pay me quasi-contract. I say, okay, I'll pay you quasi-contract, but I just lost all my profit. Okay? If I'm supposed to charge you $1 million for the building and I'm going to make a $100,000 profit, I don't get my $100,000 profit. So when I sue and collect quasi-contract, I forfeit all of my profit. That's a major forfeiture. In fact, the only reason I got into this contract with you was for the profit. And I just forfeited it all because I finished 2 days late. Well, isn't that a disproportionate forfeiture? Of course it's a disproportionate forfeiture. It's unfair. However, and so if you go through substantial performance, you will find that using these factors here, that, I probably substantially performed. However, suppose that this building I'm building for you is a big tent on your property, and the reason for the big tent on your property is that there's going to be a wedding, and we're going to use this big tent to house the people in the wedding, and that are participating in the wedding. And the wedding is going to be January 2nd. And if I finish, and you told me that, I knew this from the beginning. Now if I finish a day late, that's a big deal. Okay? And finishing on time was a substantial part of the contract, a material provision in that case. But in the other case where you weren't inconvenienced by me finishing a couple of days late, finishing on time was not a material provision. So if finishing on time is a material provision, the answer is it gets enforced. If it's not a material provision, if I have substantially performed, it results in a disproportionate forfeiture. The courts will not grant that, and therefore if I have substantially performed, that will be sufficient, and you will pay me the contract price for the tent minus whatever damages you incurred from being 2 days late, and in my hypo there were no damages at all for that. So that's how substantial performance works. The disproportionate forfeiture works in the way I mentioned, where you end up with the courts will not allow these disproportionate forfeitures, and the examples I just gave you, the time is of the essence was one such example. Another example is where I finished the apartment building and you keep finding these little things wrong with it and so forth. So this will be a reason. Preventing the disproportionate forfeiture is a reason to excuse an event. Divisibility is the final one. Let's suppose I have a contract where I'm supposed to deliver coal to you for the next 15 months and I deliver it for 10 months and then I quit. So I've breached. Now the deal was that you're going to pay me at the end of 15 months for everything, for all 15 months of delivery. So after 10 months, I breach and you don't pay me anything. You say, gee, Emerson, I'd love to pay you, but a condition preceding to my duty to pay you is that all the coal was delivered for all 15 months. And if we don't say that in terms of conditions, we say that the events which must occur in order for their duty to pay me to be absolute is that the coal was delivered for 15 months. It wasn't. It was delivered for 10 months, and you say, so no duty to pay. Well, one of the things we might do about that is to say, well, I delivered the first 10, and so why don't we divide this contract up instead of one big contract into 15 small contracts? And we can do that provided each part sort of has separate and independent value by itself. It's something you might have contracted for on its own. For example, you might have bought 1 month of coal from me because that has value by itself instead of 15. So if you have 15 deliveries, you have a number of performances. I perform, you give the counter performance. I perform, you give the counter performance. If the problem can be broken up in that way and each performance has its own separate value, then you can treat that as a divisible contract. When I'm building the house for you and I build a foundation, the exterior and the interior, those things don't have the same kind of separate value that delivering coal to you 1 month does. The foundation to a house doesn't have that much separate value without the house, whereas delivering the coal, you can stay warm for 1 month. So if the contract is divisible in the sense that I just described to you, then what the courts might do is to say, well, here's what we're going to do. We're going to treat this like 15 separate little contracts. And the first 10, Emerson has performed. So pay him for all 10 of those. And the last 5, he hasn't performed. There's a breach, so sue for your damages caused by the breach. And that's what the divisibility is all about. Now, so you see what these conditions are about. These conditions really aren't conditions as such. I mean, you can call them that if you want to. But it's really more descriptive to refer to them as events which must occur in order for my duty to become absolute. Now, you can back up for a second and point out to you that it's not magic that the events occur and cause my duty to become absolute. It's that's what we agreed to. See, when we formed the contract at the beginning, the deal was that I will buy your house for $100,000 if I can get a loan from the ABC loan company, if I in good faith apply and can get the loan. If I don't get the loan, I don't have to buy your house. Well, we agreed at the beginning that my duty to buy your house, depended on the occurrence of this event. and that we agreed if the event didn't occur, I don't have to buy your house. And so the fact that my duty matures or it becomes absolute when the event occurs, that's what we agreed to begin with. And so that's the way it's going to be unless the court finds something wrong with the event. And things that may be found wrong with the event are things like the event may be impossible. The event is prevented by somebody. The event may be waived. Enforcing it would cause a disproportionate forfeiture. So these are all things that are wrong with the events, the reasons why the courts will treat them in some different way. So we understand how the occurrence of these events triggers someone's duty to become absolute. They don't perform, then that is a breach of contract. We understand that things can go wrong with these events, and here they are. And there's one more thing that can go wrong with the events that I want to call your attention to, and that will be the end of the lecture. And that one more thing that can go wrong with the event is that, remember that when we negotiate this contract, that my duty depends on the occurrence of some event, that this event can be absolutely anything in the world. And I can describe events, like I said to you earlier, which are now impossible. My aunt, or whoever it was, will never make 96. The architect is dead, and so forth. But suppose I describe an event which is ambiguous. We're not quite sure what the event means. How do you interpret what the event is if it's ambiguous? And the answer is that you do to that just like you do with any other contract provision that's ambiguous, and that is you try to figure out what the parties actually intended, and the contract turns on what they intended if what they've written down is ambiguous. A good example of that was a case where a general contractor was building a house for someone. They had a subcontractor who was doing the plumbing, and the contract between the general contractor and the subcontractor said that the general contractor will pay the subcontractor within 5 days after the owner pays the general contractor. And of course some dispute arose with the owner and the general contractor, the owner. The years have gone by and they still haven't been paid. And so is this poor subcontractor now supposed to wait years to get paid by the general because the general is having a dispute with the owner? And the court said, well, you know, that's what the words said, but that's not what these people intended. That these people have done business before, that in the industry people use this kind of language. They used it when they did business before. The industry uses this kind of language all the time. And what the industry means by this kind of language is, yeah, you pay the subcontractor within 5 days of when you get paid by the owner. But if you don't get paid by the owner, you still pay the subcontractor within a reasonable time. And so the court said what these people really meant was that. You pay the subcontractor within 5 days of when the owner pays or within a reasonable time. And so again, the court is looking at the event that was described and saying the event that described was ambiguous. Well, the words were not ambiguous. Actually, the words are very clear. But they're still going to enforce what the parties intended more so than what the words actually said. And that is what you need to know about conditions. You understand their role in the law of contracts. You understand the things that can go wrong with the conditions. Here they are on the board. You understand the consequences of these things going wrong. You don't always excuse a condition because there's something wrong with it. Depends on which one it is. You have to look at them on a case-by-case basis. And that, I hope they ask you a question about conditions because you know more than you need to know about it. And that is the end of this lecture.